Hey, welcome back to Kelly's Take Two review, all about Unit 2. We've just been trudging right through Unit 2 together. We have conquered two sections, of Unit 2, and we're about to head into Section 3 of Unit 2, all about estates in real property. Now, the term estate in real property is not the type of estate we might think of. And in class, we talked about what comes into our mind's eye when we hear the word estate. And many of you said things like the Biltmore, which I love, because yes, the Biltmore is right down the street from me, the Biltmore estate. Some of you said somebody's assets when they pass away, their estate when they pass. That's a good one too. And it took y'all a minute to guess my favorite estate, my favorite connection with that word, which is going to what? An estate sale? Come on, let's go pop some tags, people. All right. So estate can mean various things to various people. The word estate means something very different in real estate class compared to what it means to us in the regular world. Estate in real estate class really pertains to our ownership interest, how much ownership we have in a particular property. Do we own the property? Do we have what's called a freehold estate? Or are we a renter? That's called a leasehold estate. That's going to show up in Unit 11. So we're going to set leasehold estate aside for a minute, and we're going to focus on what's called freehold estate. Now, freehold estates can be broken down into a couple of different categories. So I'm going to pull up my whiteboard once again, and we're going to draw a few diagrams that will help us visually remember the difference between the freehold estates in this unit. Now, I will tell you up front that it would appear as if this whole section on estates in Unit 2 has been substantially decreased in terms of its testing focus. So go through this review, and if you really want to get it down pat, go for it. If you just want to sing the Frozen song, let it go, that's completely legitimate. You have 800 pages to get through in a 6-week period. Oh my stars, you only have so much bandwidth. So I'll leave it up to you. All right, let's go ahead and grab a clean sheet of paper. We're going to draw a diagram of the various types of freehold estates in real estate. Now, again, if you are simply listening to this as a form of review while you're out doing something else, feel free to speed up my speech. You can get through it a lot faster. Many students enjoy doing that. All right, let me grab my whiteboard, and you've got your clean sheet of paper. You might have some colored pencils or magic markers or so on and so forth. Let's talk about it. So let's go ahead and title this Freehold Estates. Here we go. We're going to talk about a few that can be inherited, and those include the highest and best one is called, look at this crazy language. Y'all, hold up. Hold up. This language is so old. How old is it? I'm talking Beowulf old. I'm talking Chaucer old. I'm talking medieval times old. So if you are looking at this language in a minute and go, what in the world is that? You're not alone. You're not alone. Okay. In class, I did a little etymology on the language for you, but since we're doing a take 2 review, I won't go into that right now. But just know it's obtuse, strange language that's left over from the way olden times. How about that? All right. So your highest form of ownership is going to be called your fee simple absolute. The word absolute was coined by a guy named William Blake in the 1500s to indicate that your property can be passed on to your heirs. Prior to that, you could not. The land that you were using or farming would revert back to the original grantor, which if we were looking at the days of jolly old England, that meant it went back to the royal family. Do know that I've got some great TikToks that I made for you regarding Unit 2. And I want you to go ahead and after this section of review, go back and watch those interesting, we'll just call them interesting little TikToks that might help it make sense for you. Okay, so fee simple absolute means that there are no limits to the use. You have your full legal bundle of rights, full legal bundle of rights. And remember, the acronym for your legal bundle of rights would be Deep C. You have full what? You have full ownership. You have full season. Nice. Well, if there are no limits in a fee simple absolute, that must mean that there are a couple other estates of ownership, freehold estates, that do have a few limits on them. And you are absolutely correct. We're going to talk about the next category. I'm going to put it over here, called fee simple defeasible. Fee simple defeasible. When I say the word defeasible, I want you to link that to the word defeated, meaning ownership can be defeated. Ownership can be lost. Good. There are one of two ways this could happen. And again, it would appear as if this topic right here that I'm about to go over with you is lightly tested. It would appear so. I can't say for sure, but there you go. So fee simple defeasible, ownership could be defeated in one of two ways. You've got one situation called fee simple determinable. I'm just going to write determinable. Determinable. And the other one, and we're going to shortcut it and call it conditional. Or condition, what did I want to call it? Condition subsequent. That's shortcut. You'll get it. Again, you might get a test question on this. You really might not. So decide how much bandwidth you want to put to this information. If there is a deed, so remember that, well, you may not know this yet because it shows up in Unit 3. A deed is the paper evidence of ownership. And another word for ownership is title. So a deed is the paper evidence of title. There may be some language inside of that deed that really creates what's called a fee simple determinable situation. All right, what does that mean? That means, and again, I've got a really great TikTok on this where I acted out. I encourage you, go to the YouTube channel and watch that TikTok. Okay, so fee simple determinable means that the new owner can only do, new owner may only use the property for one thing. For one thing. One and one only. If they break that rule, guess what? Here's the big feature right here. We have an automatic reversion. Reversion where? To the original owner or their heirs. What's the owner called? The owner's called a grantor. So if someone says to you, okay, I'm going to donate this 1,000 acres for a school for the blind, for instance, and the new owner takes possession and says, yep, we're only going to use this 1,000 acres for a school for the blind. And then 10 years down the road says, ooh, the real estate market's hot, hot, hot. Let's raise some more money by doing what? By building a tiny home compound, maybe on a back corner of the 1,000 acres. Well, if the original grantor or any of the original grantor's heirs find out about that, they're going to have something to say about that, possibly. They're going to come back and say, hey, we told you you could do one and one thing only with this property. Now you've done something else. No. And guess what? No fuss, no muss. That property will transfer back to the original grantor or their heirs automatically. No fuss, no muss. Period. End of story. Okay. Now let's contrast that with fee simple condition subsequent, which is a shortcut version. That's a mouthful to say the whole thing, but you'll get the idea. So in this situation, condition subsequent, the new owner may do, excuse my handwriting, may do anything with the property, oh, that's really bad, except ... Except what? We don't know. Whatever condition the original grantor puts on this transfer of ownership, any condition, if the new owner breaks that and does that one thing that they're not supposed to do, now we have a fee simple condition subsequent. We've got to go see the judge and decide how we want to proceed. So in this situation, we involve the judge. Let's see how I want to say that. So the consequence, we're going to have a court proceeding. We're going to have a court proceeding to determine future ownership. So we're going to go before the judge. The judge is going to say, well, let me give you an example. Let's say that you have a grantor. They donate property this time for a summer camp for children. They say you can do whatever you want with this property as long as you do not sell or serve alcohol on the premises. So that's the condition, no alcohol. Years go by and the new owner says, ooh, here's a new business model. I can have summer camp for grownups, which is a real thing, y'all. Did you know this? Summer camp for grownups in the off season and make some money, because what's more fun than summer camp for grownups than the zip line or the canoe ride accompanied by an adult beverage? I'm just saying. I haven't done it myself, but it sounds fun. Anywho, well, if they start doing that in order to increase revenues and the original grantor catches wind of this somehow, some way, that original grantor is going to come back and have some words with the current owner and say, hey, I put a condition on this transfer of ownership, this transfer of title, that you could not serve or sell alcohol on the premises. And clearly there's plenty of evidence that that is exactly what's going on here. Well, from that point, we've got to what? We've got to go see the judge. So the original grantor, the original owner, has to file a court proceeding, go see the judge. Judge Judy's going to say, well, what do you want to do? Do you still feel so strongly? Are you still so strongly against alcohol? Or are you seeing that this is a great business model and maybe you want a piece of the pie? Okay. So you get a wait and see period. The original grantor gets to decide how they want to proceed. All right, that ends that. Okay, y'all. Hopefully that was helpful. Next, we're still in estates. So give me a second. I'm going to clear my board and we're going to talk about your favorite and mine. Let's talk about life estates. Listen, life estates back in the days of King Arthur were the way of the world. That's just what we did. We had life estate back then. Why? Because people in power, the royal family and so forth, they wanted to keep ownership of as much property as they possibly could. So what they would do is the royal family would say to some other prominent residents, shall we say, some of folks with title, they might say, you know what, you did a good deed. So by protecting me, the queen, therefore I'm going to grant you title to this 5,000 acres of property. Do with it what you want. But when you die, the property will revert back to me, the queen. That's just how it was. So you could still put together a life estate, and some people do. They do this to transfer assets sometimes before a parent ages into needing skilled nursing care, or sometimes people use a life estate in order to protect their children's inheritance when we have a second marriage, those sorts of things. Well, how does it work? Again, this whole section of Unit 2, in my opinion, as your testing coach, has been somewhat downplayed. So if you find life estates too confusing and you just want to sing the Frozen song, that is perfectly fine. That's up to you. You have 800 pages to conquer other than this. All right, so in a life estate, a conventional, so let's title it that. So a conventional life estate, conventional life estate. You have a few players. You've got the grantor. The grantor is going to grant a life estate over here. So this is the life estate holder. I'll just call him a holder for now. Okay, that means that the life estate holder can use this property. So the life estate holder may use the property as they wish without harm. So they can't commit what's called waste. They can't harm the property. So they may use the property as they wish without harm for their life. Okay, they are going to have the legal bundle of rights. So they're going to have the full deep sea legal bundle of rights while they are alive. They will be in complete control. That means technically they could sell their life estate. Technically. Now, that's goofy to think about. Who in the world would do that and who in the world would buy it? But again, because they have their full legal bundle of rights, the D standing for disposition, you can dispose of the property. Technically, that life estate holder or life estate tenant could sell their life estate. Doubt that would ever happen, but there you go. Now, what happens when the life estate holder croaks out? They pass away. They're gone. Well, one of two things could happen. Okay, so when they die, upon death, we have two situations we could set up. We could set up a reversionary interest, reversionary situation, or we could set up a remainder. If we set up a reversionary interest, then the property reverts to the grantor. I'll show that to you in a different color right here. So if we're going to do number one, then when this person croaks out, okay, they pass away, then that property will revert to the original grantor automatically. No fuss, no muss, no Judge Judy, no lawyers, no one's involved. End of story, period. Try to fight me on it if you're my cousin, my brother, whatever, and you want to have that property. Nope, not going to happen. It's going back to the original grantor. All right, what about this remainder situation? Let's put that in a different color just in case that's helpful. All right, so if we have a remainder, well, that doesn't look very much different, does it? Hold on. If we have a remainder situation, let's make it green. Okay, then that means when this person croaks out, that the ownership of the property will go to someone else, called the remainderman. The remainderman. It could be anybody. It could be a friend of the original grantor, and the original grantor will name who the remainderman is. It could be a friend, a relative. Technically, just for giggles, it could be a nonprofit. I mean, who knows? It could be anyone as the remainderman. All right, so that's life estates simplified. Except, you know where we're going. There's got to be one kind of odd scenario, which there is. So here we go. We're going to talk about a life estate for the life of another. Whoo, you guys love this one. Okay, so let me clear my board and you get out your drawing materials as well. All right, let's label this one life estate for the life of another. The fun language is life estate pour à travers. Pour à travers. Oh, so fancy. So fancy. I know you feel so fancy saying that. But again, like I said, it would appear as if that fancy language is being downplayed to some degree. We're just going to hit it straight up, straightforward. Right. That's funny considering this concept. But so a life estate for the life of another. How does it work? Why would you do it? Well, first, let's talk about the mechanics of it, and then we'll talk about the why. I'll see if I can give you a story, a scenario. So when you have a life estate for the life of another, again, you have someone who owns the property, and they are going to grant a life estate to someone else. So you have a grantor, the grantor is the owner, and they are going to offer a life estate to this person over here. And we'll call that person the life estate holder. You might say life estate tenant, but I don't want to confuse you if you are a renter, yada, yada. So that's someone who has the life estate. And again, they've got the life estate. They have their full legal bundle of rights. They've got their full deep sea. Okay. They can't commit waste, meaning they can't harm the property. Why? Because the grantor may get that property back at some point, and it should come back to them in good condition. All right, so we've got this life estate right here. Very good. Now, who is this life of another? We don't know, but we need someone else. So let me draw another person. We need another individual down here. This person, believe it or not, is called the measuring life. How would you like to have that title? Can you imagine? What do you do for a living? Whoops, I wrote the word title instead of life. What do you do for a living? Oh, I'm just a measuring life. Like that, remember Schoolhouse Rock? I'm just a bill on Capitol Hill. Well, this person's just a measuring life. I'm just a measuring life. That's all I do. All right, so this person here, the life estate holder, can stay in the house, may own the property or have rights to the property. May own, let's put have rights, may have rights to the property as long as the measuring life person, I know, isn't it so obtuse? The measuring life person is alive. Isn't that crazy? That is so crazy. So what that means is if the measuring life person croaks out, they croak out, then unless we have a remainderman, that means when the measuring life person croaks out, that the property is going to revert back to the original grantor, and this person is booted. This person is kicked to the curb. This person is kicked out. Go find somewhere else to live. See ya, wouldn't wanna be ya. That's how that works. Okay. Why would somebody do this? Ooh, let me see if I can think of an example for you. All right, I'm going to draw it again. Hope that's okay with you. So I'm going to clear this. Let's set up a story. Let's tell a little story. All right, let's say we've got a person over here, and he is the responsible brother. He's just a good egg. He does everything by the book. He files his taxes on time. He pays everything on time. He got straight A's in school. He takes care of his parents, yada, yada. Well, he's got a brother over here who is just, this guy is the black sheep of the family. I guess we could say that. Black sheep brother. He is irresponsible. He just never follows through. You can't depend on him or whatnot. He is just a situation. Well, let's pretend that he has a daughter. He has a daughter, and this daughter has some type of a disability. So this daughter has some type of a disability. Well, the responsible brother is concerned that his black sheep brother is not going to do right by black sheep brother's daughter. So this is black sheep's daughter with the disability. I hope you're following me. I don't know. We'll see. All right. So responsible brother, who is the uncle essentially to the daughter down here, is worried. He wants to make sure that his niece with the disability always has a place to live, a roof over her head. He wants to make sure of that. And he is concerned that his irresponsible brother is not going to do right by her. So what does he do? Well, naturally, the responsible brother, not only is he just a great guy, he also has quite a robust investment property portfolio. And one of his homes has just become vacant. And he says, okay, brother, here's what I'm going to do. And I'm doing it for my niece, not for you, because you are on my nerves. He says, I am going to grant you a life estate for my rental house, which will not be a rental house anymore, but for my investment property, let's just put house, at 123 Main Street. Okay, I'm going to give you a life estate for that. You can live in that house, do what you want, yada, yada, as long as, so I'm going to grant you a life estate for how long? For as long as your daughter or my niece is alive. Which should be quite some time. I mean, she should outlive her dad, ideally. Am I right? So she should have a place to live for quite a long time. So that's great. So that's how that works. And she would be the measuring life. So as long as she is alive and she's got a roof over her head, then we'll have this life estate with the irresponsible black sheep brother. Very good. Now, I'm going to take it a step farther. You might just want to tune me out because this is getting a little bit complex. I get you, but yeah, it's in the book. Okay. So let's say that, oh, bless her heart, something happens to her. Oh gosh, something happens to her and she croaks out. She croaks out. So the measuring life is what? The measuring life is gone. So what does that mean? That means black sheep's brother is what? Kicked out. He's got to leave. His life estate is over because his daughter is no longer with us. Right now, let's reverse it. What if he croaks out? I don't know. Let me see. Let's draw this over again. Okay, let me draw her again. Thanks for your patience. Okay, there she is. She's the daughter with the disability. All right, now what if Black Sheep brother croaks out? Now remember, his life estate is for her life. She's still alive. That means his life estate, if he dies, can be what? Inherited. By who? By his other kids. And of course, his daughter with the disability. She will remain the measuring life. So let's say he's got 2 other kids over here. They can all stay in the house as long as their sister is living. So what do you think she's going to get for presents for her birthday and for the holiday season and so forth? She's going to get multivitamins. She's going to get all kinds of healthy self-care things because they're going to want to keep her alive. Okay. And that concludes our review of life estates. See you in the next video.